For today's story, we cover the latest in Tati Westbrook's legal troubles as new lawsuits get filed in Nevada. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we're covering a new lawsuit involving Tati Westbrook. Tati Westbrook has been a time-to-time feature of the channel. We got our start being exposed to the world of Tati Westbrook through the world of Katie Joy Paulson, who we've also talked a lot about on this channel. Tati Westbrook is a beauty influencer and has a YouTube channel that's very, very popular and with many, many millions of subscribers. And she has beauty lines and so forth and so on. Unfortunately, she's had some difficulty in her business relationships as it relates to her business partners through a whole bunch of problems. And now we have the latest and possibly greatest in Nevada, which is the home of the corporate form. So we will read this and see what is going on. Let's get started with this. In or about November 2020, Mr. Swanson, the business partner, called a childhood friend of Miss Westbrook. During the phone call, Mr. Swanson disparaged Mr. Westbrook by telling the friend that Mr. Westbrook had removed his mother from life support to steal his sister's inheritance, and that Miss Westbrook should be worried for her safety. Yeah, I mean we've heard this before via Katie Joy Paulson. So yeah, okay. Let's carry on. During the same phone call, Swanson threatened that he had an embarrassing recording of Westbrook that he would release publicly to ruin her reputation and career if she did not contact him immediately to settle a lawsuit then pending in California. Danger, Will Robinson. Sounds like that might be extortion and blackmail. Let's read some more. Swanson told the friend to pass the threatening message along to Westbrook, and that Westbrook must take action to resolve the California lawsuit or he would ruin her. Sounds more like the blackmail. Swanson further informed the friend they'd also reached out to members of Westbrook's family to warn them he had an embarrassing recording he intended to use to ruin Westbrook if she did not settle the California lawsuit. More with the blackmail and extortion. Okay, possibly, allegedly. Upon information belief, the recording that Swanson referred to in the phone call and that was being used to extort the Westbrooks is an illegal, secret audio recording that Swanson took of a confidential business meeting that occurred in Swanson's home in California between the Westbrooks and Swansons. California is a two-party consent state, so they both need to know the recording is happening for it to be legal. The Westbrooks had no knowledge that the audio recording of their communication was taken, and they did not consent. That would be what would make it illegal in California. Not all states, mind you. Many states are one-party consent. Not California. From the time the Westbrooks learned that Swanson had made the illegal recording and couldn't learn, Swanson had been continuously absent from the state of California, thus tolling any statute of limitations pursuant to California law. So they're trying to say that they're within the statute of limitations because he had absconded from the jurisdiction. Technical argument, we'll deal with it later, I'm sure. As a direct proximate result of the conduct, including illegal recordings and attempted extortion, the Westbrooks have suffered financial damages and severe emotional distress. Okay, so let's try what we got. Invasion of privacy under California law. Because Swanson's recording was made in California, California law applies to the legality in effect. Sounds right. California law provides the legislature hereby declares that the advances of science and technology have led to development of new devices and techniques for the purpose of eavesdropping upon private communications, and the invasion of privacy resulting from the continual and increasing use of such devices and techniques has created a serious threat to the free exercise of personal liberties and cannot be tolerated in a free and civilized society. The legislature by this chapter intends to protect the right of privacy of the people in the state. Fine. The California law prohibits a person from recording a confidential communication without consent of all parties, which we often call two-party, because normally there are two parties, but of course all parties is more proper. A conversation is confidential if a party to that conversation has an objectively reasonable expectation the conversation is not being overheard or recorded. So this would, for example, preclude any situation in which the recording would be obvious or otherwise noticed by appropriate signage or something like that. Mr. Swanson surreptitiously recording a private business meeting between the Westbrooks and him that took place at the home in California. The meeting was a confidential business meeting, and Westbrooks had an expectation of privacy as to the communications during their meeting. Yeah, they had objectively reasonable expectation the conversation was not being recorded. If it's in someone's home, that would seem to do the trick, yes. The Westbrooks have no knowledge of and did not consent to the recording of their communication during the meeting. The illegal secret recording of the private business communications was made for the purpose of harassing the Westbrooks and or to harm Westbrook carefully built brand and reputation. Okay, maybe. Swanson's secret recording of the confidential communications violates the law, and as a result, they're entitled to relief under law, including but not limited to statutory damages and or triple actual damages by enjoining Swanson from releasing the audio recording. The Westbrooks have been forced to hire attorney to pursue this action. Okay, but this is all California, and we're in Nevada. So my first question is, why is this appropriate cause of action here? Because the business, well, hold on. Because it is Toddy Westbrook, the individual, and James Westbrook versus Clark Swanson. Is Clark Swanson, oh, hold on. Oh, that's why. Clark Swanson is a resident of Nevada. Okay, never mind. Clark Swanson's a resident of Nevada. That will do the trick. So you should be able to get it down there. But the recording happened in California. We might have a fight over venue. I can see a venue fight happening down the line. Well, we'll deal with that later, I'm sure. Right, so let's talk a little bit about what I'm talking about, right? So we've talked about jurisdiction issues before. Jurisdiction is where we can sue the people. We probably have jurisdiction here because he lives here. The Nevada courts have general jurisdiction over him. So this is a proper jurisdiction. But it's not necessarily the only proper jurisdiction. The call apparently occurred in California, which would make the act that occurred in California. So that would be a place appropriate jurisdiction too, in California. So we got two places apparently appropriate jurisdiction. We've got Nevada and we've got California. Now, normally, when you have two different places of appropriate jurisdiction, it's plaintiff's choice. You can pick one or the other. But that isn't necessarily always the rule. And there is an idea about venue, right? So what is the best venue for this? Well, it is California law. It's California's courts, California's statutes, California's everything, right? The recording happened in California. So, you know, the home was in California. So maybe California is a more appropriate venue. But of course, then the only way this comes up is for Swanson to ask for venue to be changed. Which, why would he? He has the home field advantage. So there's really no reason for him to. The only other thing he could do is bounce this up to federal court, I guess, if he wants to, which might make sense. But because as long as, we'll have to see where it is in the call of relief. Because we got a diverse party, as long as we're asking for more than $75,000 in damages, which I imagine we are, then the defendant could bounce this up to federal court. They call it removing it to federal court, is a technical name for it. I'm not sure why they call it removing, but they do. So he could remove this to federal court, potentially. He could also say it's his improper venue and move it to California, but why? That's more inconvenient for him. So it's not an issue unless he brings it up, but worth noting anyway. Let's carry on. Oh, California already said you don't go here? Okay, that'll do the trick too. That'll do it. Fair enough. Which wouldn't make sense for him to then relitigate and say, I want it in California, because he'd be collaterally stopped. So yeah, so someone in chat said that they've already had this fight in California, and they said it's an improper place here. Okay, fair enough. So that means that the only reason that would be true is because Swanson himself asked for that. So the courts agreed with him. Nevada, of course, is bound by that judgment, full faith and credit clause of the Constitution. So they are bound by that determination of California. So now they're in Nevada. Nevada is an appropriate place because he lives there, and he can't now come back and say, no, I want venue in California, because he just said I didn't want it there. So he's collaterally stopped from making that issue. So his only thing left he could do is remove it to federal court, which I think is still an option. But thanks for the no. Appreciate it. See, we learned something positive that we can put in the edit. It's all good stuff. All right. So under the relevant law, the courts of record within their jurisdiction shall have powers, rights, status, and other legal relationships that they would have. Yeah, that's basically the All Writs Act, basically in state law form. There is a present controversy between the Westbrooks and Swanson. Sure. The foregoing substantial controversy is right for determination. Adverse interest. Okay. The recording is made illegally, may not be used in civil proceeding, no right to use to maintain the recording, and the Westbrooks are entitled to relief. Okay, they're forced to hire an attorney for this. All right, so what do we want? Treble statutory damages, award of punitive damages, judgment and award that the recording was made illegally, injunctive relief, and such other relief. Well, they're not asking for an exact dollar figure. And they're not saying, it doesn't seem clearly obvious that's more than $75,000. So I'm not even sure that they can punt this up to federal court. I mean, they can try, I suppose, but there doesn't seem like there's enough here to remove this. The nice thing you'd like them to say explicitly, we're suing for not less than 75,000. Well, more than 75,000 to be exact. They have to say more than 75,000. Not saying that. They're saying it's triple statutory or triple actual. And then it's like, well, is there any reasonable possibility of this being more than $75,000? No, not really. So I think we might be stuck in state court. So I think we're stuck here. Although they could try to remove it. But yeah, that's what's going on. Pretty interesting stuff. So that brings us to the end of the discussion for the moment, the Toddy Westbrook and James Westbrook versus Clark Swanson thing. We want to exempt this from arbitration because we want equitable and extraordinary relief in the form of the injunction. Maybe. Although courts do like the arbitration, so they might want it to go to arbitration first and then issue an injunction, or they might do the injunction and do arbitration. I don't think you're getting out of arbitration all the way considered, because that just doesn't seem like that's going to happen. But you can try. So yeah, that would be the next thing. Either Swanson tries to kick this up to federal court, maybe, although I think he has a problem, or he tries to invoke the Federal Arbitration Act and say this should be arbitrated. And that they're asking for injunctions under relevant law, but the way the Federal Arbitration Act is interpreted, it's interpreted extremely broadly. So I would not be surprised if the Nevada court kicks this over to private arbitration for any sort of award. And then if there's an award, then they can have injunctions afterwards in pursuance of the award. I don't think they'll get in on the front end. They're not going to get out of this completely. They're not going to get an award of damages, I think, from Nevada. That seems unlikely. So I'd imagine we're not long for this world in state court one way or another. But we'll follow it for as long as it does. And that, for the moment, brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.